The acceptance of appointment for a guardian ad litem for use within the Oakland County Probate Court system. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover this particular form, which if you look at the bottom left corner is PEMH 1141. This is a specific form used by guardians ad litem in the Oakland County Probate Court only, so it's specific to that probate court. And really what it's trying to do is consolidate a lot of information to ensure that when the guardian ad litem files a report, that they include all of the required information within that report. Because if they do a narrative report, it may miss some of the essential information that the judge and the court or the statutes would require and want. So this particular form used within the Oakland County Probate Court, it's an acceptance of appointment, which means that the guardian ad litem appointed by the court pursuant to statute or court rule is accepting the role. And then it's a report of a guardian ad litem. Now again, don't confuse guardian ad litem from guardian. A guardian is a court-appointed fiduciary on behalf of a legally incapacitated individual. A guardian ad litem is the eyes and ears of the court, appointed by the court to report on particular matters within a proceeding that may be going on. So a guardian ad litem is often and usually an attorney, but it doesn't need to be. It's appointed by the court to be able to report to the court and give background information and make a recommendation as to a particular petition. Let's work our way through this particular document. In the matter of would be the estate name or the guardianship individual. It identifies that the person has been appointed guardian ad litem and that they accept the appointment. And number two says that they've performed all of the duties as required under the statute MCL 700.5306, including a review of the court file, the Internet Criminal History, access to a report, investigated the existence of a power of attorney, which is POA, or PAD, which is patient advocate designation. And the court wants to know whether if somebody is being sought to be guardian, whether there's an existing power of attorney or a patient advocacy, what we used to call living will, as well as identifying that the interested parties of that individual have all been appropriately identified, confirm that a proof of service has been filed with the court for the upcoming hearing, and again, investigated assets. So if in fact the assets of that person, of the ward is the protected person, the incapacitated individual. There's a space for the guardian ad litem to identify if assets exist. Now that may just simply be Social Security, but it also may be funded bank accounts. The second part, the second red rectangle here, starting at number 3, identifies the date of the visit. And there's a date for the place and location and date of that particular visit of the individual. So the idea here is that the guardian ad litem is going to do a visit and report on the visit itself. And it says, to the extent that the individual could comprehend, I explained the nature, purpose, and legal effects of a guardian's appointment and otherwise complied with the statute. Now, why do they use that preliminary language? Well, somebody may be incapacitated, unable to communicate. So the guardian ad litem, even though that person is incapacitated, it still has a duty to explain statutorily the requirements under the statute about that the individual is being sought for guardianship, as well as who the person being sought guardianship, who the nominee is. It identifies some checkboxes here that the individual alleged to be incapacitated does or does not wish to be present at the hearing, which is one of the requirements, that there are that the least or less restrictive alternatives to the appointment of a guardian have been sought. So the idea is that guardianship is an extraordinary measure. If there are limiting abilities or powers of attorney or patient advocacies that could perform the role of a guardian, then the guardian ad litem is to report that there. That the individual objects or does not object to the guardian having authority over DNR, do not resuscitate, which is the statutory requirement. And then D, the individual either objects to the appointment of the fiduciary, the person nominated, or objects only to the nominee, but would prefer somebody else. So the idea here is that the the guardian ad litem is reporting to the court whether the person being sought protection over objects to the nature of the petition and or the nominee, the person being sought to be the guardian. The next is the recommendation of the guardian ad litem that there's a denial of the petition, an appointment of a temporary or limited guardian, full conservator, etc., and whether there's a surety bond requirement. Now, these are statutory pieces, kind of requirements, and often guardians ad litem will just write all of this information in a long narrative. But the goal here is to make sure that the guardian ad litem follows all the statutory requirements and court rules. So for example, on this same form, it talks about the duties of the guardian ad litem. Let's work our way through it. That there's a visit, and that visit is generally in person. Explain the nature, purpose, and the legal effects of the appointment of a guardian, even if that person is unable to communicate or respond back. Give the individual the PC form that outlines their rights. It's like an advice of rights form. Inform that if a guardian is appointed, that there could be a do not resuscitate order in place, and explain the scope of it. Explain the right to contest, a right to request limits, a right to request a particular person to serve, a right to be present at the guardianship hearing, to have legal counsel. And so if there's an objection to the appointment of the guardian or the guardianship, there is a right to legal counsel that will be appointed by the court. Inform the individual of the name of the person that is being sought to be appointed the guardian. Ask the individual about any monies, cash, that are available so that there could be a determination whether a conservatorship is needed. And then again, make determinations and inform the court of all of the things that we just spoke of. So these are the ideas that the guardian ad litem is reiterating to the person that is being sought guardianship over all of their rights, to ensure that they are well informed of their rights, because they may not be able to attend a court hearing. So it's really critical that the guardian ad litem fulfills their role and reports accurately to the court about the nature and circumstances of the guardianship or conservatorship petition that is before the court. Now remember, this is a form specific to the Oakland County Probate Court, but the ideas are universal within the state of Michigan. The idea that these are the requirements of a guardian ad litem as part of its visit within a petition for guardianship or petition for conservatorship. At the Probate Pro, we are passionate about everything probate. If you've got questions about this particular form or any probate-related issues, visit us at theprobatepro.com or call us at 833-PROBATE.